Your Honor, and may it please the court. My name is Saumya Jhaveri, and my co-counsel is Vedanth Ramabhadran. And today we are representing the petitioner side in the case of Espinoza versus the Montana Department of Revenue. As an overview, the crux of our argument rests in the idea of equal opportunity. We truly believe that if a secular organization is getting a benefit, a sectarian organization should not be compromised because it is religiously affiliated. Throughout this case, a variety of landmark cases will support this argument, and key decisions in Trinity Lutheran versus Comer, and Peter versus Weddell, and Mitchell versus Helms all prove the idea that a sectarian organization deserves the same liberty and justice as a secular organization. Before I begin the argument, I would like to go over some really important facts of the case. Kendra Espinoza, Jerry Anderson, and Jamie Schaffer are three hardworking, driven women who are motivated to pursuing the best for their children. Unfortunately, after Ms. Espinoza's daughter was bullied in public school, she took the proactive step in taking our daughter to a private institution, Stillwater Christian. In 2015, the Montana State Department of Revenue enacted a tax credit scholarship program, which gave $150 tax credits to donors, and then that money then transferred to an organization called Big Sky Scholarships, which transferred that money to low-income families such as Ms. Espinoza's. However, in time, Rule 1 was enacted, which completely blocked this, in parallel to Article X, Section 6 of the Montana Constitution. At this point, petitioners appealed to the process and said that Rule 1 was unconstitutional. Petitioners today also uphold this belief that Rule 1 is indeed unconstitutional because of the Free Exercise Clause.
Well, Counselor, let me ask you a question. We've talked a lot about Free Exercise Clause. How do you think the Establishment Clause plays into this case?
So I think that in a lot of cases, such as Zelmer versus Simmons-Harris, the idea of the Establishment Clause came up in part of the decision. But I think the focus of the question is that does the Free Exercise Clause violate, does a religiously neutral aid program violate a Free Exercise Clause? And because of that, I believe that we should be focusing primarily on the Free Exercise Clause because the question pertains to that. But there have been cases where the Establishment Clause, as I'll further describe in Simmons versus...
Well, let me ask you a question. Do you think the Montana Supreme Court got it right or wrong? Were they, under Montana law, could this scholarship program exist the way it was structured?
So, the district court actually ruled in favor of the petitioners, but the Montana Supreme Court ended up reversing the decision, saying that Rule 1 was actually going to be unconstitutional. And what we believe is that Rule 1 is indeed...
Rule 1 was constitutional under the state constitution or the federal constitution?
So what the Montana Supreme Court held that Rule 1 was indeed constitutional under the Montana Constitution, Article X, Section 6. Okay. But under the federal constitution, the petitioners are arguing that Rule 1 is unconstitutional.
Wait, no, I get that. But do you think that Article X, Article 10 of the Montana Constitution is constitutional?
Article X, Section 6, which states that direct or indirect payments or cities and towns. Your Honor, Justice Blackmun, I believe that that part of the Constitution is constitutional. However, Rule 1, which discriminates and further clarified that part of the Constitution, is unconstitutional.
So are you asking us to declare the Montana Constitution unconstitutional?
No, today we're only debating about Rule 1, which clarifies the Montana Constitution in saying that...
But isn't Rule 1 required by the Montana Constitution? You say clarify. Isn't that required?
Yes. So Rule 1 was enacted to further modify the Montana Constitution. It actually added in the sectarian clause by saying that sectarian schools also could not receive the aid.
But let's say we agree with you, right? And let's say we kill Rule 1. Mm-hmm. Ms. Espinoza still can't get funding for her religious school, right? Even if we strike out Rule 1, Espinoza can't get what she wants because of the Montana Constitution, Article 10.
Yes, so at that point, we would have to debate whether the actual Article X, Section 6 of the Montana Constitution is in violation of the Free Exercise Clause.
Isn't that what we have to do here? Don't we have to simply say that the only way your client gets her relief, right? Your problem isn't really with Rule 1, it's with the Montana Constitution.
So what we would say is that the neutral aid student program that's being discussed under this provision is under the Montana Constitution. So we would have to declare the Montana Constitution unconstitutional for Ms. Espinoza to get the tax.
So do you know how many states have these sorts of no-aid provisions in their constitution?
So overall, I don't know specifically, but I do know that Washington State does have such a program, and essentially in that case where we saw the Washington State have the religiously neutral student aid program, they actually ruled in favor of Trinity Lutheran, which goes with this case.
I mean, I'll tell you, I think about 37 states have these. Do you think that all these provisions are unconstitutional?
So, Justice Blackman, I would have to specifically look at the provisions described in the states to further analyze that.
Fair enough. But let's just talk about the Montana one for a minute. What's your strongest case for the position that the Montana Constitution Article 10 is unconstitutional? What's your best case?
So we reference a couple of cases. The first case that I would like to point out is Mitchell versus Helms in 2000, where the plurality opinion, by Justice Thomas wrote that if, quote, the religious, irreligious, and a-religious are all alike eligible for governmental aid, no one would conclude that, quote, indoctrination that any particular recipient conducts has been done at the behest of the government. We also have Zobrist versus Catalina Foothills and Witters versus Washington Department of Services for the Blind, which both upheld that religious schools right next to non-religious schools, as long as the families, not the government, decide which school to send their children. And because the tax credit program gives the parents the liberty to choose where they want to send their children, for example, Ms. Espinoza chose Stillwater Christian, she has that liberty. So on that precedent, we would believe that the Constitution or religious schools have to be right next to non-religious schools.
What about Trinity Lutheran?
So in Trinity Lutheran, what I would say is that because they ruled in favor of Trinity, we draw the comparison in case that because the money flowed through the grant program and then was given to the church, the Trinity Lutheran school, in this case, similarly, the money is being flowed through Big Sky scholarships and then is being given to the school, Stillwater Christian.
Well, just be clear, what was the money being used for in Trinity Lutheran?
So in Trinity Lutheran, I believe, Justice Blackman, that the money was being used to resurface playground parts, and specifically the Montana Department of Natural Resources was making these parts and then was giving grants to companies. And then from there on, Trinity Lutheran applied for the grant and was rejected under Article Act Section 7 of the Montana Constitution. Because
hold on. Just Trinity Lutheran was from Missouri. Are you talking about...
Missouri, Missouri Constitution. Yeah. And from there on, it was understood that because Trinity was a religious organization, a public infrastructure company like the Missouri Department of Natural Resources could not give the money to Trinity.
Okay, so in Missouri, the money was being spent on rubber chips for the playground to keep kids safe. What is the money being spent on here in Montana at Stillwater? How will the money be spent?
So the money is being spent to give scholarships to students, which under Zobrist versus Catalina Foothills is decided that religious schools and non-religious schools can exist as long as the parents, not the government, decide where to send their children.
Right, but what if Stillwater decides to buy Bibles with this money? Is that problematic?
Sorry, could you repeat that, Justice Blackman?
What if the Stillwater Christian Academy decides to purchase a bunch of Bibles with this money from the state?
From the state?
Oh, the money from Big Sky. What if they decide to buy Bibles with that money? Is that okay?
So Stillwater Christian does embrace Christian principles and values. So I would say that in the status quo, Stillwater Christian is already doing that, perhaps, because they have to teach their children, because it is a private Christian school. They're probably already teaching their children Christian principles. And that
do you see a difference, Counselor, between purchasing rubber tire chips for a playground and purchasing Bibles? Do you see a difference between the two things?
Yes, there is a distinguishment. However, the similarity between the two cases is that both institutions are religious. Both are getting money, whether direct or indirect, from the state. In Espinoza, it's from Montana. In Trinity Lutheran, it's from Missouri.
All right. Counselor, talk a little about Locke v. Davey. How do you distinguish your case from Locke v. Davey?
Yeah, so, Your Honor, so Locke v. Davey is actually a very narrow case in the decision. This counsel believes that the decision that was made in Locke v. Davey was extremely divisive in the fact that after the decision was made, the ruling specifically, lower courts expressed much disconcern over the case and essentially were very divided on what the proposition was. In fact, in the Trinity versus Lutheran case, when the Supreme Court tried to apply the Locke v. Davey case, it was not very successful because the Locke v. Davey case was actually made in a very divisive era, which is what we do.
Okay.
So furthermore, we would like to reference a couple of other equal opportunity cases that really exhibit the principle of religious and non-religious schools standing by each other. In Wisconsin versus Yoder, it was ruled that religious schooling is a free exercise right, which means that stripping the ability to engage in this desire is unconstitutional in terms of the First Amendment. The court also found in this case that, quote, depriving families of scholarships, specifically what we reference in this case, is simply because he or she wants to attend a religious school is unconstitutional under the Free Exercise Clause. This is also a really good case to uphold the petitioners because it was specifically declared that stripping a student just because they are receiving a scholarship is unconstitutional according to the First Amendment. Our second argument relies on the intentions of the Montana Founding Fathers. Siding with the respondents in this matter, we believe, would be sending across the message that Rule 1 does not violate the First Amendment, but problematically, the fundamental principles of the tax credit program and Rule 1 contradict each other. The fundamental principle of Rule 1 is that no aid can be given to religious organizations, but the tax credit program is that it can consider any third-party organization and any qualified education provider. So Rule 1 and the tax credit program fundamentally contradict each other, even if they are religiously affiliated.
Well, then maybe the remedy is we just declare the Montana Constitution unconstitutional. Can we do that?
That could potentially solve the problem, Justice Blackman. However, what I was getting to in my proposition was that in the Montana Constitutional Convention delegates in 1972, the founders of the Constitution, quote, were seeking to avoid jeopardizing the precarious historical balance which has been struck between opposing doctrines and countervailing principles. So when you side with the respondents, you have two contradicting principles in Montana, which is precisely why the Founding Fathers made the Constitution, which they wanted to avoid.
Right, but why can't Montana take efforts to avoid knocking down the wall between church and state? They're not required to give vouchers to the school. Why can't they say we want to avoid any establishment clause violations? Why is not that a valid ruling?
So addressing the idea of school vouchers, Justice Blackman, in Zellman versus Simmons-Harris and Everson versus the Board of Education in the Township of Ewing, in both cases, the judges ruled in favor of the mindset that every family and student should be taken into account when it comes to a program like a tax credit program. And this not only includes secular organizations, as I've described before, but also those affiliated with religious institutions. In both of these cases, it was described that the private choice was upheld in the situation, as they were able to choose in Zellman where in Ohio they were able to go to school. So they had that individual liberty.
Okay, Counsel, you have about a minute and a half left. Can you proceed?
Yes, Justice Blackman. So we can also reference a similar situation in Ronald versus Rosenberger, which is an important case because the Supreme Court settled on a 5-4 decision when a student was struck down for publishing a paper in the newspaper as his First Amendment rights were being violated. And the similarity between Rosenberger and Montana versus Department of Revenue is that secular institutions have to be in consideration for scholarships. When you side with the respondents, those aiming for religious institutions would be null and void, as in the Montana Constitution. In another landmark case, Winmer versus Vincent, a student-led organization at the University of Missouri, was a religious institution, but the Supreme Court confirmed that it was a violation of the Free Exercise Clause because specifically, the individuals in the cornerstone organization barred the students' ability to exercise their religion on campus. Similarly, in Montana, not allowing scholarships to go to students applying for religious institutions prevents them from exercising their religions before they even get on campus, regardless of what happens after the students arrive on the Stillwater Christian's premise. In all, Justice Blackman and your Honorable Justice, we believe that at the end of the day, a theme in our case is that secular organizations and sectarian organizations have to be given the same benefits. Multiple cases such as Peter versus Weddle and Mitchell versus Holmes describe this as being as a distinct line between the two. And for these reasons, we believe that you should uphold the petitioner's case. Thank you.
Right on time. Thank you, Counselor. Okay, we'll now have 5 minutes for rebuttal. You can begin whenever you're ready.
1 second, please.
Yep, take your time. That's okay. Good angle. Good lighting.
Is this good? Can y'all hear me and see me?
Loud and clear.
Cool. All right. Is everyone ready?
Whenever you're ready, Counsel, you can proceed.
Unequal rules for equal players creates unequal outcomes. Your Honor, and may it please the court, my name is Vedanth Ramabhadran, and with my co-counselor Saumya Jhaveri, we continue to be part of the pitch case that believes in the Espinoza versus the Montana Department of Revenue case that the religious schools should not be treated any differently than secular schools. The first argument that's focused on by the respondents focuses on the idea that the state withholds the right to not fund specific organizations. The crux of this argument rests in the Locke versus Davey case, where the Washington State Scholarships Program did not give a scholarship to a student trying to major in devotional theology. However, there are 3 discrepancies between the case at hand today and the Locke versus Davey case. Number 1, in that said case, the judges at the end in the 7-2 decision literally agreed that there was no intentional hostility towards religion. This is very different than in the case at hand today, because in the Espinoza case, it is blatantly obvious that Rule 1 was passed in order to prohibit scholarships from being given specifically to religious or sectarian schools.
Hold on, Counsel, let me just interrupt you. Wasn't Rule 1 enacted because of Article 10 of the Constitution? Weren't they required to adopt this rule? They couldn't, consistent with their own state law, give the scholarship to the Christian Academy.
Right, but the implication of it is that this rule in its actual text says that specifically states do not have to give cannot give scholarships to those schools that are sectarian. The problem with the Rule 1 is that it specifically isolated that, objective in sectarian, preventing these scholarships from being given to them.
But did they have a choice under the Montana Constitution? Doesn't the Montana Constitution say you can't give aid to religious institutions?
Like my co-counsel said, we can debate that at another time, but the question at hand today is focusing whether or not this rule introduced is against the free exercise clause of the First Amendment. Whether or not the Montana Constitution was also unconstitutional is a question at another time. We can answer that a little bit later in another sort of argument.
I think you have 2 other points. You can proceed.
All right. Second, another discrepancy is that in the Locke versus Davey case, the scholarship program was state scholarships. But in the case at hand today, the Big Sky Scholarships Organization is a private organization. Governments withhold the right to their money. Even if that argument is true, the money never flowed through the government in this case. It went through a private organization, not a state organization. Yes, Justice Blackmun?
Let me interrupt if I can for a minute. What role does a state play with the Big Sky program? What role does the state play?
It was the tax credit agency. Is that I think that's what you're alluding to.
The government's giving tax credits to incentivize people to donate, right?
Sure, but the point here is that unlike the Washington State Scholarships Program, the money itself never actually flowed through the government's hand. It flowed through the private organization's hand.
But do we have entanglement concerns that the state is being entangled with these religious groups?
I'm sorry, can you repeat that, Justice Blackmun?
Are there concerns about entanglement, right, where the state is entangled with these religious institutions?
Those concerns can be brought up, but they are still very different, and a distinct difference between the case at hand today, the Espinoza case, and the Locke versus Davey case. That discrepancy within itself is a reason that case cannot be applied in terms of past precedent. All
right, about a minute and a half. Want to get to your third point, please?
Yes. The third reason as to why this case cannot be treated the same as the Espinoza case is that, as my co-counsel said, it was given in a divisive and narrow judgment, and they couldn't really see what side the petitioner was arguing from, which is why in the Trinity Lutheran case, it could not have been applied properly. The respondents then go on to their second argument about the Establishment Clause. However, Your Honor, the question relates to the Free Exercise Clause, not the Establishment Clause. Therefore, on face value, we would deem that these arguments are null and void. But even then, We would say that the Big Sky scholarships were religiously neutral, which means that they weren't actually taking the side of a Catholic church or any specific organization. They were supporting the idea of religion, not going to one specific religion.
Right, but when we talked about preference, you're giving aid to religion, right? And again, that runs right back into the state constitution, which you say is for another time, but I don't see how you avoid it.
So let's look at the overall implication or the topic at hand today. We are trying to decide whether or not that the students going to religious organizations and non-religious organizations should be treated in the exact same manner. Whether or not the actual jargon, maybe the Constitution or the Rule 1, the idea itself is that they need to be treated with equal opportunity, and it is still the petitioner's belief that they needed to be treated with equal opportunity due to the multiple cases in the past, such as the Trinity Lutheran case, the Peter versus Weddell case, and the Mitchell versus Helms case, that it is of utmost importance that we treat them with the same opportunity.
Okay, thank you so much, Counselor. Okay.
Thank you.
Thank you both very much. That was excellent. I know this isn't easy. I ask lots of really hard questions where I ask you to take a position, I make you draw a line, and then as soon as you draw the line, I push you over the line to try to see where you fall. I think you both did very well. I'm very impressed with both your performances. You know the case law well. You stuck to your guns, which is always very important. So I'm very, very impressed. Sebastian, is there anything you'd like to add?
Thank you so much.
Yeah, I'm impressed. Likewise, I've been feeling this way about all the competitors. There's no way that I personally could have done this in high school.
Nope, not a chance.
And frankly, a lot of teams, in fact, every team except yours has been at least sponsored by a teacher. So doing this because of your own initiative, of your own volition, is all the more impressive. So,
yeah, very good. And I'm going to make an offer. Whenever we return to normalcy, I want you guys to come visit my class sometime. When do you graduate? This year?
Well, no, we're juniors, so we actually have one more year.
Okay, God willing, we have school next year. Right, so if you're in Houston at some point next summer, maybe before your classes begin, you're welcome to come visit my class whenever you want. I'd be happy to have you as my guest, just see what it's like. I think you can go to head to toe with any of my law students. You're good.
Thank you so much.
Do you have questions for me or Sebastian?
You said the results were going to be announced next week?
Yeah, our last moot, I think it's on Monday, so we want to judge everyone before we release the scores.
Okay.
I have a question as well.
Sure.
Is there anything that you thought that Saumya and I could have done better, or like a specific focus that you thought we either lacked in or could have done better in?
That's a good question. Yeah. So let me answer. One of the difficult parts of oral arguments is where the judge asks you to take a position that you don't want to take. In this case, the question was, I kept asking over and over again, do you think that Montana Article X, right, that Article 10 is unconstitutional? And I think at some point you more or less both said, yeah, it probably is, but we don't have to decide it now. But I think you should be more willing to not fight the question, so to speak, right? And say, well, Your Honor, I don't think we have to do it, but if the court had to decide it, we would say it's unconstitutional. And that sort of being upfront lets you save like 3 or 4 minutes of awkward questioning, because you're trying to. And I know you're trying to fight it. You're trying to stick to your guns. But sometimes you can say, Your Honor, we don't think the court has to decide that today, but we do think that the Article 10 is in tension with the Free Exercise Clause. See Trinity Lutheran. And then once you make that acknowledgement, then the court can ask some follow-up questions. But it's you have to know what ground you're willing to give. Now, there's some ground maybe you can't give, because if you give the ground, you lose. But here, I think actually the argument that Article 10 is unconstitutional helps you and actually bolsters your case. Beyond that, I think your cadence is good. Your pacing is good. You didn't read too much from your papers, which is always tricky. I think another thing that's always difficult is when the judge starts talking, you have to stop right away. It's so not natural, but like even if you're mid-sentence, you just stop. And whenever the judge interrupts you, you always say, yes, Your Honor, no, Your Honor. And just put Your Honor at the end of every sentence. Yes, Your Honor, yes, Justice, no, Justice. It's not natural, but the way I do it, pretend the word Your Honor is a period at the end of the sentence. And whatever your sentence is, just end it with comma, Your Honor. And then like you're not going to be considered informal. I cut you slack, and I cut all high school students slack, but you're asking how the pros would do. I think that's one thing you could do.
All right.
But I think you both did well, I'd be happy to have you come visit my class anytime.
All right. Thank you so much.
All right, you guys. Thank you so much, and I'll see you next time.
All right. Thank you.